y'all think you're tired of these cases, she's pissed. I will say that if y'all file something and it doesn't get accepted, just email me, y'all have it. I'm the one that has to accept all of y'all's filings for these cases.
We apologize to you, by the way.
It's alright, but I know that sometimes I'm in court, so if you email me,
Hello, everyone again. Thank you. Sit down. Don't no need to stand. Thank you, though. Okay.
if there's any attorneys on Zoom, let me know.
Oh.
Make sure to email us.
Yeah, I will. Yeah, I don't have a. Yes. Maybe I'll have this stuff. Okay. No court reporter this afternoon?
She should have been here.
On her paperwork, it only had the morning. That was only requested for the morning. She double checked the paperwork and I looked at it too, so it only had this morning's case number on it, this morning's time, there was nothing for this afternoon on the paperwork.
I have to step down anyway because I grabbed the O2 sheet and not the O7 sheet. So you can look into that. I'll be right back.
She double checked everything, triple checked it, and like, yeah, I guess your paperwork doesn't say you have to be back, so I guess not.
Oh, Mr. Picorni. No, that's okay. Well, I have an administrative thing that does not involve Mr. Picorni. So just to clarify, according to my chart that we made, everyone has filed a motion to dismiss with the exception of the state defendants and then Edwardsville, CUSD number 7. Is that correct, everyone?
That's what I have, Your Honor.
Okay.
Yes.
And does anyone know of any counsel appearing, just observing the live feed? Anyone know? Okay. Didn't know if you did or not, but thought I would ask. So this is doing a housekeeping matter that didn't involve you.
Your Honor, for the court reporter, we did order one. I'm not sure why she's not here. Ms. Mr. Verticchio just had a good suggestion, which is if the
Judge, I certainly don't have any objection to that if my colleagues, for those that are listening now, on my client's behalf, they are all I've been seeing is that when we had it this morning, that when I started talking and then when I quit talking, it was not on social media, so they're all in the conspiracy mode right now. I'm kind of chuckling, but nonetheless, I'm being jocular. My point is, as long as it's capturing it, I certainly don't have a problem with that. But it seems that there may have been some connection issues this morning, but maybe that just means it doesn't make it out to the world. Maybe it's being recorded right now internally somewhere, which would be fine.
I just sent Brian an email, if we can wait a minute to, I know he's here.
Maybe he's capturing it locally on a hard drive or something. I mean, I've been to courthouses where that's the only transcript you can even really have. So.
Live on YouTube right now. That's the part that says it's working. It's a little delayed. 'Cause you just sent that on here.
I'm sending him a text. Because it says, according to his email, he's out of the office, which I know is not true. Because we all saw him this morning.
Hey Brian, could you come upstairs? Okay. He was just writing an email, but he's going to come upstairs.
Oh, that's, he can. Would you go ask Jenny though? Because I guess Jamie's not here. If there is any court reporter available, that would be. The problem is we have court reporters are out and this and that, so we don't have available. But if there's someone back there who's available, then we could use them.
it took us a while to find one.
Did it?
Yeah.
They're all flying planes.
Is Mr. Gerber coming, or it's just you, Mr. DeVore?
I don't think so, man.
All right. I just want to ensure.
It does capture it. However, this morning I was having some connectivity issues. When that does happen, I'm not capturing anything. It is being recorded to YouTube. However, it's not meant to be a record. Do you know what I'm saying? So I mean, if it needs to be a record, I would suggest a court reporter.
Yeah, we're just
Yes, ma'am.
trying to do a last minute.
I understand. I mean, that's
Pivot, yeah.
just my, unless, I don't think I can put it to hard drive.
What's that?
We can't get
No.
I'm okay with proceed. I mean, I'd rather not push it off.
I agree with you. I don't have an objection to that either.
So,
Let's proceed.
If it was our first time ever talking about these issues,
Right.
maybe, but
yeah,
it's not like we're going to say something. Yeah, I'm not worried about it. It's up to you.
yeah.
I guess all of you, I guess. Judge, I'm just telling Mr. Picorni, and we're all listening on, if we don't have a court reporter, the plaintiffs have no objection to continuing, given that you've heard this stuff ad nauseum and your ruling's going to be your ruling. I'm okay with it. I don't think Mr. Picorni has an issue either. You'd have to ask all the other attorneys, I think, but.
I mean, continuing this afternoon, not continuing.
Yeah, not if we don't have the court
Okay.
reporter. Yeah, yes, ma'am.
Proceeding with the argument.
Continuing with the case, yes, ma'am.
I mean, the other, I don't know where that lady was from. Was she from Springfield? Anyone know?
I believe she was. My assistant's trying to get in touch with her now, so
Do you know what agency
I don't.
it was? I know area-wide court reporting is a local agency, but Did she leave? Did anyone get her card?
She didn't have it.
She didn't?
No, I don't think so. I didn't get one.
Did she happen to leave any contact information with you? Yep.
Is there anything else?
No, I just wanted to make sure that it was being recorded.
It is being, like I said, it is being recorded, but if I have dropouts,
Right.
it's a technical thing. I just.
You're not recording it locally,
For that.
right?
I'm doing this wirelessly, which the more cell phones and things like that get on there, sometimes I can't overcome that, so.
Yes, sir.
Thank
So, I'm willing to proceed, if you guys wanna wait till 2 o'clock and see if you can get an answer from your office. I mean, we're not gonna go more than 2 hours, are we?
I certainly,
Half that, hopefully.
yeah, if that.
If that's okay with everyone, if anyone has a
That
burning
makes sense to
desire
me.
to proceed right now, I guess we could do that, but, because if it's someone, I mean, Springfield's pretty small, and most of the court reporting agencies are downtown, so
Right.
if she could get a hold of someone,
Yeah, let's wait till 2, Your Honor, and then we'll
okay,
proceed if we can.
let's do that then, okay.
Really grievous that for 5 minutes, I'll transcribe by hand.
Seriously, take a turn.
Yeah.
Talk slow, I can type fast.
You're live still.
Mr. Swain will get all the way to the end and he'll go, in short. That's 10 years from now, that's one of the things we're gonna remember. In short. That was class. I love it.
Before it gets misplaced. Yeah.
not yet been able to reach the court reporter. They're talking to the scheduling person, but my guess is we're not going to have somebody here.
Just roll for everybody else.
Yeah, I mean, I don't want to hold things up all afternoon, so.
Yeah, I get it.
I think everyone's good.
I
with
think all the
proceeding.
lawyers are in
Probably
agreement.
get them back into
Yeah.
work with to make sure.
That was just me asking. Judge will be in a couple minutes.
Nobody adjusts.
Oh my God, leave me alone.
And not just a blanket complaint. Yeah, that makes sense. How many you got in this? Just one, right? Yeah.
Okay. Thank you, everyone. Have a seat. What did we discover?
So, no luck, Judge. We weren't able to get a hold of the court reporter. Scheduling person tried to reach her, but no answer. So I think everybody's in agreement that we're going to proceed with the argument. And
Okay.
if there is a YouTube recording, we can ask to have that transcribed later if all the parties stipulate to it, but we'll go ahead.
Okay. And do you all know how to get that recording? Because I don't.
Yeah,
You
my
do?
office is capturing it right now. as well,
Okay.
so
Okay, well, good.
we could send the whole recording to the attorneys if it becomes necessary.
Right.
And if I recall correctly, I do know from back in January, Brian kept it up until I issued my order, and then he
Right.
took it down. So I suspect he will do something similar here. And since he is aware of the situation,
Right.
he can leave it up until,
Yeah, instead of me giving mine, he could give his, which is more
I'll just
correct.
have Brian leave that up
Right.
until,
If it's publicly posted, we can just point the court reporter to it.
Yes.
Absolutely.
okay. Okay. So we are here then on 21 CH 5007. As I went over earlier, Mr. Picorni, everyone has filed a motion to dismiss with the exception of the state defendants in Edwardsville CUSD number 7. So we're here on, looks like the majority of them are 619.1, and then there is a couple 615s as well. So, who's going to take the lead? Mr. Picorni?
I will, Your Honor, but I'm going to be really brief. We have filed our motion to dismiss. It's essentially the same arguments that we have made to the court multiple times in briefing the prior motions for temporary restraining order. The court's June 21st order denying the last TRO motion against Chicago Public Schools is directly on point for the arguments that are being raised here. So we've moved to dismiss based both on lack of subject matter jurisdiction for, again, all the reasons that have been previously argued and that the court addresses in its June 21st order, finding that the court lacks subject matter jurisdiction over the claims against Chicago Public Schools. We've moved on behalf of the four districts that we represent in this case. The same arguments apply to the other three districts. To be very clear, we're asking for dismissal as to those districts on the 619 motion to the extent that there's any doubt about that. With respect to the 615 argument, again, it's exactly the same argument that we've made before and that the court addressed in its June 21st order. And for the very same reasons that the court found that there was not a likelihood of success on the merits as to these claims in its June 21st order, the court should find that the plaintiffs have not stated a claim here. The plaintiffs have not filed a response to the motions to dismiss, and therefore we'd ask the court to rule based on the motions and the supporting papers that have been filed in this case. And for the same reasons as in our prior motion or in the prior argument on the Austin case, I would suggest that plaintiffs should not be allowed to argue in response to the motion. I understand the court's ruling in Austin, but at the very least, to the extent that there's any factual issues, we'd note that the plaintiffs have not presented any different evidence, any contrary evidence to the affidavits and other evidentiary record that's been presented by any of the defendants, and the court should deem all those facts admitted. So for all those reasons and the reasons that we state in our motion papers, we ask the court to dismiss the claims against our four clients in this case. And of course, we reserve
Yes.
our opportunity to reply to whatever arguments Mr. Tor might have.
Okay. Who's next? Anyone?
Just very briefly, Susan Nicholas from Robin Schwartz on behalf of Staunton School District, CUSD 6. I'll rely primarily on the pleadings. I just want to highlight the fact we also have a standing issue, and that the named plaintiff, Nicole Pottist, has resigned her position with the district. So there is truly no standing for her to proceed against the district.
Okay.
And because of that lack of standing, the matter should be dismissed against Staunton School District in its entirety.
Okay. Anyone else? It's gonna be way shorter than 2 hours.
Decatur Public Schools will also stand on our pleadings and reserve any response for the rebuttal.
I can't
Okay.
come up with something on.
Go ahead, Mr. Swain.
John Robert Swain, for our clients, we actually joined the motions followed by my colleagues, which were all very well put, in the comments that have been made in here today. I just want to also put a similar point upon the 615 concern that I raised this morning in the related case, but it's even a little more pointed here, I think.
Okay.
In a complaint without any individualized allegations about any particular policy adopted by any one of our respective clients. We not only have that concern about needing the specificity, the fact pleading of which policy any of our clients might adopt that becomes disputed, but even here we have the particular concern that we have the appellate court ruling saying that our clients actually have the authority to adopt those local policies. And so I think that actually really puts the additional thrust behind the argument that even trying to cure this to a 615 amendment would be in vain and leave the issues to them.
Okay. Thank you. Anyone else?
Just going to say, Lisa Calloway, I'm from Belvedere School District 100, and I think my colleagues have sufficiently stated the arguments that are reflected in our brief and our reply as well. So we will join in their arguments.
Randall Slater, the same on behalf of Springfield and Roanoke, Benson. Your Honor is obviously very familiar with the issues at this point, and we've set our position in our briefs and tried to argue with my colleagues.
Okay, thank you. Anything from you? You're always very boisterous before.
Well, it was different before, Your Honor, no. I'm good here. I'm here on behalf of North Mac 34, Yorkville 115, Triad 2, Marion 2, and Jasper 1, and I don't have anything to add aside of what my colleague so articulately stated on the
Okay.
record. And it's in our pleadings, thank you,
Okay.
Judge.
You're the only one left.
I'm sorry, Jeffrey Gaster for Eureka, District 140. Just on the 2615, I think the appellate court has ruled we have law of the case, and on the 2619, we have an uncontroverted affidavit from our superintendent that they're not enforcing these policies. They haven't been enforcing these policies since your TRO in February, so this case is moot. We can stand on that.
All right. Mr. DeVore. Anything new?
A little bit. Not new. You know, I wish nothing more, Your Honor, than this particular issue to be able to go to the 4th Appellate District. I think of some local workplace-related authority, which we do have some precedent on.
Okay.
I think that precedent's flawed, but until the Illinois Supreme Court says otherwise, that's the law of the state. Whether they'll go as far when this goes on appeal to say they're... That is still very much alive and well in this case, and it's ironic. I mean, Mr. Berticchio is not here today on any issue, as the court's aware, so he can't speak to it. But they answered the complaint, as you're aware.
All right.
Right? They've answered the complaint. So, we heard this morning very lengthy rendition from the Assistant Attorney General about the guidance that has now presented itself since all of these pleadings were filed, about how at least 5 different ways it's do what you want, it's voluntary, etc. If the guidance as it relates to vaccination and testing is mandatory. We still have an executive order, 22, that while many of the provisions of that executive order have been, I don't know, quasi-legislatively repealed by the governor, for lack of better, I don't know what even words to put on that stuff anymore, but the provision as it relates to vaccination and testing, I think it's part 3, Executive Order 22, still there. So, ironically, there is a case of controversy here between all the parties, even the school districts. Because you have an executive order, it's part of this case. You now have new guidance that refers to it specifically. To promote vaccination in school communities. It's public record, Judge. It's the CDC, or the IDPH-ISB. Executive Order, Section 3 of Executive Order 2021-22 was reissued and remains in effect. Accordingly, school personnel must establish they are fully vaccinated against COVID-19 or submit to testing. Yet you have every school district in this case, except for one, asking you to dismiss this case as moot with affidavits that they aren't enforcing it. Boy, if we'd have just had that same situation and when this case was filed, whenever it was, boy, what a different world we would be in. So now we have a situation to where we have an answered complaint by the governor and the other state parties with a mandate in place. Every one of these school districts is saying that they're violating it, allegedly violating it. Now, you also have the order that was issued in this case in conjunction. It was on February 17th, as the court's aware of that case. It was your case where Your Honor issued a restraining order that had to do with vaccination and testing. After that, JCAR suspended the rules. The court's aware of that too. And I'm reading from paragraph 15 of that order from February 17th. The state defendants argue the now expired emergency rules were not and are not necessary to effectuate EO 2024's modified quarantine. Appellate court, 2 words. We disagree. So, there is an issue in this case of whether, and again, that ruling I believe is relevant, of whether or not this executive order, which still exists today, Section 3, is binding on the school districts. They're here to say to you that they're not following it. Practically, I think that's great. But from a case in controversy, it's still an issue. It's still an issue. And I haven't seen anything filed in this case yet where the governor has either rescinded Section 3 or stipulated to the court that he agrees with the 4th appellate that he can't enforce it absent emergency rules. That still has to be answered, ma'am. It still has to be answered. And again, so to be able to dismiss this case, I think is inappropriate. Now, they're going to say, well, we've submitted affidavits, they're uncontroverted. Absolutely true. We're not enforcing it. That's an admission that creates the controversy, because they're admitting they're not enforcing something that the state parties are proclaiming must be enforced. That has to be addressed in this case. If not for that issue having to be addressed, I would love to take this issue up to the 4th Appellate District on the issue of let's call it the Glass/Allen ruling on a workplace inherent authority issue. It needs to be resolved. But if the court were to say, okay, I'm going to follow that precedent, it doesn't get rid of the case, because we still have this other issue. Again, it's the big elephant in the room. It's still an issue of we can't get a final appealable order, sadly, when that issue is still alive, and it has to be addressed. And that issue, by its very nature, involves every one of these parties. Involves them all. Well, I don't know how it involves the Edwardsville School District yet, because Mr. Mundorf hasn't replied for his clients, but as to all of the parties here, their own affidavits create the case in controversy between everybody. So to merely try to limit it to, jurisdiction's lacking because it's a workplace issue, etc., that's only part of the conversation, Judge. The other part has to be addressed. Until the court addresses that, everybody in this case has an interest in that question, has a big interest in that question. So for that reasons, again, I am reluctantly saying we can't dispose of this case and send it up, because that issue has to be solved first, and all of these parties in some fashion are going to have to figure out how they want to address that. And absent the governor stepping up sometime real soon and doing like he did in the higher education, the colleges. There was a case filed in Southern Illinois, and shortly thereafter the governor rescinded section 2 of that same order for higher education. Well, that rendered it moot as it related to the state parties. You don't have that here. So we still have this issue that has to be addressed in this case, Judge. Until we address that issue and we get a final ruling on whether the executive order of the governor, absent emergency rules, but with this guidance, its very language is mandatory in it, whether that places obligations on the districts, and moreover, whether the districts are going to use that to compel vaccination and testing and not some inherent authority. Those issues still have to be addressed. Thank you.
Thank you. Mr. Feeney.
Your Honor, I need to clear up the case under the appellate court ruling. That argument is set forth in our briefs. I don't see any reason that Decatur Public Schools needs to be left in this case if Mr. DeVore wants to continue to litigate with the governor. That can happen absent the school districts being here. And the appellate court has told us if the school implements this, they have the right to do that. So the schools don't need to be here. And we don't need to continue to spend taxpayer money to have schools along for the ride for litigation that may remain open between the state parties and the plaintiffs. But I think before we did anything else, we need to clarify, and I believe there are other parties that are similarly situated in that not everyone is bringing a mootness argument before you today.
Yeah, because I have Decatur with the 615 and Springfield 186, 615, and then Roanoke, and then Oswego, Plainfield, and Mascoutah. 615 and a 619.
Correct.
Your Honor, I have Roanoke, Benson, Springfield, and you are correct. We have a 615. Our position is the law of the case is the law of the case. It really doesn't matter whether or not our clients are following the executive order. The 4th District Appellate Court's already ruled on the vaccination and testing issue, and the case against my client should be dismissed. Whether or not that creates an issue regarding the appeal, I think there are ways but I don't think that should stand in the way of my clients being dismissed from this lawsuit.
Okay. Mr. Thorne?
So, Your Honor, for our part, and again, we have CPS, Plainfield 202, Mascoutah 19, and Oswego 308, just to be clear which districts we're speaking for here.
Okay.
On behalf of our district, Field 202, Mascoutah 19, and Oswego 308, just to be clear which districts we're speaking for.
Okay.
On behalf of our district, Field 202, Mascuda 19, and Oswego 308, just to be clear which districts we're speaking for here.
Okay.
On behalf of our district,